The broadcast is now starting. All attendees are in listen-only mode.
Welcome everyone to the July 2018 HR Best Practices webinar series. My name is Kevin Mosher, Certified Specialist by the Minnesota State Bar Association, and I'll be your presenter today. This month, really like this topic. I've talked about this a lot over the years because it's been such a hot topic. So this month we're going to talk about independent contractors, misclassification, how most companies that I'm familiar with, through reading and, familiarity, make mistakes with regard to the classification of people who should be employees, mistakenly classifying them as independent contractors. I think it's very common. And maybe it's at your company, maybe it's not, but I do find it to be a pretty common thing, and so do the courts and the Department of Labor the last several years. So we're going to talk about that today. For those of you who need your HRCI and SHRM credits, after the presentation, a certification will go out to you once we confirm attendance and all that. If you didn't mark the box when you registered that you need HRCI or SHRM credits, just reach out to us and we'll make sure to get that certification over to you. On the right side, for those of you who are new, welcome. But on the right side, we are, I'm happy to take questions. So you'll see there's a little box and you can type in your questions. If you raise your hand, that's not going to do me any good because everybody's on mute here. And so it's just me talking at you, and just makes it a lot smoother. We've had, years ago, we tried to have the back and forth and ended up being feedback loops and all that. So that didn't work out very well. So feel free to type your questions on the right box, and I will, through the course of the presentation, I'll take a look at those and try to get to them if they're not addressed already in the presentation. So, welcome again, and let's get started. We're going to bounce around quite a bit with different laws. I hate to dwell on laws too much on these webinars. I really like to focus on best practices, but it's kind of unavoidable when we talk about independent contractors. It's just, there are factors, there are elements. No independent contractor situation is going to be alike. They're going to be very difficult. So they're going to be very different, and they're going to be based on the circumstances. Now, the good news for you is there is no set absolute standard, bright line standard, where you can say like that is absolutely 100% an independent contractor, or not an independent contractor. It's going to come down to facts. It's going to come down to a variety of things, and the factors that we look at are going to vary from state to federal, and then even among the federal, there's going to be a bunch of variation between the different agencies that have their own laws to apply. So, for example, we'll talk about the IRS and how the IRS, and everybody kind of knows this. Even laymen, know it. People who aren't HR specialists and practitioners know that, they've probably heard of the IRS 20-factored test. Well, it's ubiquitous, but it doesn't mean that it's going to be appropriate in all situations. Then there's the Fair Labor Standards. Yeah, and we've heard a lot in the news about Uber and Lyft and exotic dancers and all that, NFL cheerleaders who are being looked at whether or not, because who are being classified as independent contractors, but they're arguing for purposes of overtime, for purposes of minimum wage law. And that's all under the Fair Labor Standards Act. They're arguing that they should be classified as employees. And in many cases, they're right, and they're winning a lot in court. And so we'll talk about a little of this later. So we're going to talk about the overview, federal laws, employees versus contractors. We're going to talk about some tips and consequences, and I'll probably give you some examples along the way. Okay. Let's talk about federal law. It's a little bit easier because really all states have their own. And so there's no way for me to talk about all 50 states and how unemployment looks at the difference between employees and independent contractors. And honestly, that I think that sounds kind of boring to look at independent contractors for purposes of unemployment. But just know that at the state level that your unemployment department might have a different, the definition of an employee for Minnesota unemployment eligibility might be entirely different than the definition of an employee for purposes of unemployment eligibility in Texas or Florida or California, that sort of thing. So common definition, basically, what is an independent contractor? This is kind of just a layman's definition, but a person who contracts to do work for another person according to his or her own processes and methods. Contractor is not subject to another person's control except what is specified in mutually binding agreement for a specified job. So that says a lot. There are a bunch of elements within that, but that tends to be how we look at independent contractors. Now, when I talk about independent contractors, I am not talking about contingent workers. And so if I'm talking about contingent workers, I'm talking about staffing agency employees, people who are hired for short durations, normally through a staffing agency. Something similar. That's a contingent workforce. When I talk about independent contractors, I'm talking about people who legitimately are independent. They might be working for short durations, but they're working on projects, and they're working and they're providing their own tools and their own time, and they have flexibility in coming and going. Those are independent contractors versus contingent workers. A lot of times they're all lumped in together, but that's not, when we talk about this, that's not technically true, especially because contingent workers tend to be working for staffing agencies, and the staffing agency is their employer. So they are actually employees of a staffing agency, even though they might be working at a third-party site for the staffing agency's client. So again, don't mean to say that independent contractors are contingent workers at all. One of the themes that we're going to see among all these factors and definitional usage is we're going to see that control is a common element. Now, again, getting back to layman's people, if you're just like at an event, an HR event or a Chamber of Commerce event or something like that, and you're talking to people that don't know HR, they, maybe they're a manager, they dabble in it to the extent that they have to do a performance review once a year or talk to HR periodically, but they don't really know HR, right? So a lot of those people will still know that independent contractors, it comes down to control. And, to the extent that you can stop them from saying that anymore, you're probably doing them a benefit. I don't know if you can get them to stop. It seems to be ingrained in people's minds from like the last 50 or 60 or 70 years that control is the big deal. And that's just not the case any longer. Courts, is it an element in most of these tests that we're going to talk about? Yes. It's a common element. Control makes a lot of sense that we look at it, that we consider it, and that we consider it heavily. But is it the end-all, be-all? Absolutely not. If control over the person's terms and conditions of employment, so when I say control, I mean control over like how they do the job, where they do the job, when they do the job, control over their terms and conditions. Control is something that employers have, right? And so it makes sense that, if I don't exert control, then therefore I'm not their employer because I'm giving them some flexibility in how they want to do it. And we see this argument made in a lot of professional contexts, right? Whether it's IT workers or just generally people saying, well, I don't want to have, I'm not exerting control. They can work from home if they want. They can come and go. But yeah, I'm giving them flexibility. Flexibility is totally, that doesn't mean anything anymore. It doesn't weigh. It's not the end all be all. So when somebody says, if you've got, somebody that you're working with or somebody at a happy hour or something says, well, that person's not an independent contractor. We don't maintain control over them. Just like, well, Okay, but what about the rest of it? Like, tell me the rest of the story, because control is just not, it's not as big of a deal as it used to be. The gig generation and the gig workforce has changed that in many ways, and the courts look beyond just control. So if you want to do somebody a favor and clue them in a little bit on independent contractors, you can tell them that control, while a factor, is it's not the overriding factor that is going to be dispositive on this issue of whether or not the person is an independent contractor. So again, when we look at independent contractors, there is no just one absolute definition of this. We have to look at a bunch of different areas. So we've got the EEOC, and the EEOC governs Title VII. So the EEOC is the federal agency, the Equal Employment Opportunity Commission, that oversees the implementation of Title VII and the ADA, Americans with Disabilities Act, and lots of other discrimination, workplace discrimination, retaliation, whistleblowing type of laws. And so in Title VII, there's a definition of what an independent contractor is. And you might be asking, why do you care? And the reason is because technically, if you've classified you being your business, or a business that you're familiar with, has classified the independent contractor the person as an independent contractor, if they're an independent contractor, then you don't owe them, then they're not going to be protected by the same laws, like discrimination laws, harassment laws. They're not employees. Title VII covers employees. It doesn't cover independent contractors. And so if you've classified somebody as an independent contractor, you don't need to worry as much about them bringing discrimination claims and harassment claims and retaliation claims against you. But if you've misclassified them, the EEOC is going to look at that. So it's rare, but it does happen. It happens more with staffing agencies and contingent workforces, but it does also sometimes happen when somebody feels like they've been discriminated against. They're an independent contractor, and then they go and they lawyer up, and they go to the EEOC, and the EEOC is like, well, wait, I thought you were an independent contractor. And then they say, no. I'm not legitimately an independent contractor. I should be an employee. And if the EEOC, and we'll look at the EEOC test in a little bit here, if the EEOC looks at the factors and they consider this, they could find that the independent contractor should have been an employee. And then boom, they've got the ability to bring discrimination claims and retaliation claims against you. So tread carefully. It's just generally not a good practice to discriminate and retaliate and harass people. Don't recommend it. But if you do it toward an independent, it's a little bit different. So, but if the independent contractor has been misclassified and they're technically an employee, like, wow, they come in and they could bring a discrimination claim against you to your surprise. The IRS, and again, much more ubiquitous, people understand, they've got the 20 factor test. We'll talk about the 20 factors. The IRS looks at all these factors, and they're one of the primary agencies historically that's taken the real lead on determining whether somebody is an independent contractor or not. And why do we care for the IRS? Well, we care because of FICA, because with independent contractors, you're doing 1099 and you're not taking out payroll taxes. But if the IRS comes in and says, no, that person's misclassified, they should have been an employee, then suddenly you owe a lot of penalties in addition to the payroll taxes over a period of their working for your company. There's going to be a bunch of penalties and assessments, and the IRS is going to tax you for that. So understanding the IRS definition of independent contractor is critical. More recently, in the last probably 7 or so years, we have seen the Department of Labor take on a much greater role in determining who is an independent contractor for their law. So the Department of Labor governs the Fair Labor Standards Act, federal law that gives us minimum wage and requires that you pay everybody overtime unless they're exempt under the rules. And that's a whole another webinar to talk about. But the Department of Labor comes in because this is where we've seen the lawsuits the last like 7, 8 or so years. We've seen lots and lots of lawsuits, lots and lots of very successful lawsuits, addressing the Department of Labor problems. And like I said, we've got exotic dancers all over the country. We've now, in the last year, started to see NFL cheerleaders. We have, in the last 5 years, we've seen Uber drivers and Lyft drivers have a lot of success arguing that they were technically employees under the Fair Labor Standards Act, and getting hundreds and hundreds of millions of dollars in lawsuits, successful lawsuits and settlements against companies throughout the United States. So there are just a lot of industries that it's very common in the industry to classify people as independent contractors and misclassify them as independent contractors. And so, pointing to what your competitors do, that's it's not only not a great defense, it's has no value whatsoever. So you can point to your competitors and how other companies use independent contractors all you want, but the Department of Labor is not going to care. The courts aren't really going to care. Monkey see, monkey do is not going to work as a legitimate defense. They're going to look at the standards, the rules that the Department of Labor governs and determines who's an employee by. States also get in the mix. So states will have, and again, all states have a different definition of what an employee is for purposes of unemployment. If it comes up for you that somebody who you thought was an independent contractor has come after you for unemployment, you'll have to take a look at the state unemployment law, maybe some cases, or just get an attorney, and fight it and address those factors. So, I don't know what your state, wherever you are, where your employees are anyway, or your independent contractors are, what that state's rules are. They're going to be similar. They're going to be similar to what we talk about with the economic realities test. We'll address in a little bit. So most of them are probably going to be the economic realities test, but they're not necessarily. So you want to take a look at the states and how each individual state defines an employee for purposes of entitlement to unemployment compensation. Wage classification, same. A lot of states have many Fair Labor Standards Act laws. Some don't. Some states out there just don't have any wage hour laws at all for the state. But most states do. And so for those states, you're going to need to look at the definition of what an employee is. So if you've got an independent contractor who's bringing a minimum wage claim against you, or an overtime claim saying that they needed to be paid for the time worked, and you're like, hey, what do you mean pay you for the time worked? You're an independent contractor. That, I'm not tracking your time, and I don't have to pay you. I'm paying you based on the contract that we agreed to. And then they argue that no, under state law and the state definition of what an employee is might differ from what the federal government is currently defining an employee for purposes of the Fair Labor Standards Act, but that state might then have a different definition that's looser, and that makes that independent contractor an employee under the state law. And then boom, you've got to pay minimum wage under the state law. You might have to pay overtime. You have to pay them for the time that they work, at least at minimum wage. So you just might have a lot of liability there under the state law. So it behooves you to have an understanding of what the state definition of an independent contractor is. And then eligibility under civil rights laws at the state level. A lot of states like Minnesota and most states have some sort of human rights act. Not all, but most do have some sort of human rights act. And again, if you're an independent contractor, you can't bring discrimination claims against a company. But if the state Human Rights Act or Civil Rights Act or whatever it's called, Anti-Discrimination Act, if the state law defines an employee different than what we see under federal law, well, you could potentially be an employer for purposes of the Civil Rights Act law for that state. You could be defined as an employer, even though you might not be under federal law. So you might be able to beat off the EEOC from filing some sort of lawsuit, but or charge there, but you might not be able to defend yourself against a state human rights claim. These are some industries that commonly use independent contractors. I always put mystery shoppers on here because I did that when I was in law school. It was actually kind of fun. So I was definitely an independent contractor. I was paid to go, and I think I went to a casino once. That was pretty awesome. I did a couple of them, but anyway, so yeah, they paid by the job, right? So, and then they didn't tell me when I had to go. They just gave me some general criteria, and then I needed to, play some slot machines and get some food or something, and then write a little report. So definitely independent contractor as a mystery shopper. Again, I don't know if mystery shopping is still even a thing. We are seeing it, where we're seeing it more so these days is we're seeing it in the gig industry. With independent contractors, we are seeing it with, the Ubers of the world, the Lyft drivers of the world. Cab drivers have always been, routinely classified as independent contractors. A lot of startups, many incorrectly, are classifying people as independent contractors. A lot of professional service firms, construction, ag, that sort of thing. So some recent statistics, we just got some numbers from the Bureau of Labor Statistics from some surveying that they did last May of 2017, and these just came out in the last couple of weeks, these numbers. And one of the interesting things about this is that the way the BLS, the Bureau of Labor Statistics, looks at this is they found, and I think this is counterintuitive because I think most people in the industry have been talking about how independent contractors, particularly with the gig economy, how independent contractors have become more prevalent, and actually BLS is showing a drop from a percentage of the workforce from 6.9% to 7.4%. Also, there are more independent contractors among older workers than there are among younger workers. So I don't know if it's just like there are that many consultants in the world, and they've just they've worked for a lot of industries and in-house, and then or maybe they're laid off during the Great Recession, and then they just hang a shingle, do their own thing as an independent. I don't know what that's all about. BLS didn't really get into the nuts and bolts from their they just issued a preliminary report at this point, so I'm sure they'll come out with a fuller report after September. That's the plan anyway. But it was interesting to see that statistically there's an indication that independent contractor usage is going down as a percentage of the overall economy. One other interesting thing is that 79% of independent contractors prefer to work as independent contractors versus doing traditional work. So they're choosing it versus in the same report, they asked the similar questions of contingent workers, people working at staffing agencies or people just working like part-time employment here and there. And as you can imagine, the percentage was much, much lower. Most of the people doing part-time work were looking for full-time work. So they were pretty dissatisfied. They were not preferring that. And then similarly, with contingent workers, it was like around 50% or so of contingent workers were fine working in a staffing situation. Pay comparable. That's one of the things. Now, what it doesn't, so the average weekly earnings is slightly, lower. That's probably like 4 or 5%. I'm just doing some fancy math off my head here. So 4 or 5% lower for independent contractors versus typically hired, non-independent contractors in the workforce. But what that doesn't include is costs of payroll taxes or which is FICA times 2 for independent contractors, people that have their own businesses. So you've got the average wage being lower, but also having to pay FICA, so that's additional. But then also the big one is independent contractors aren't part of like a group medical plan, so their medical coverage is and benefits, they're not getting any of the benefits that typically come with full-time work at a typical company. Obviously, not every company has full-time benefits and everything, but it's common enough. So there's a huge gap there in the non-wage benefits and compensation aspect. So overall, independent contractors make significantly less. There was also an NPR poll that defined things differently than the Bureau of Labor Statistics, and they found that about 20% of the jobs were held by independent contractors. And when they did their reporting on that, based on their statistical analysis, they found that, 1 in 5 jobs are held by independent contractors, whereas the BLS, that 10.6 million, wasn't necessarily measuring jobs. They were just measuring people who are primarily independent contractors. Now, a lot of people, so for example, a lot of people might have full-time jobs, but then be Uber drivers on the side. Well, BLS isn't measuring them because they're considered full-time workers, whereas the NPR poll was looking at jobs itself in the economy. And that to me sounds much more appropriate, that 1 in 5 jobs is held by an independent contractor. Also, you can see this other statistic: 94 of net jobs created are impermanent, which is another way of saying independent contract type of work. And again, that's your Ubers, your Lyfts. That's almost the entire economy of net job growth over a 10-year period, which just gives you a pretty good idea of how important the gig economy is to the United States as far as growth in the job world goes. Okay, so the IRS. So let's look at the IRS. We're going to look at each of these federal laws, and we're going to these federal agencies, and we're going to look at the factors that they look at, and you're going to see a lot of overlap. And again, control is not the end all be all, but there's a lot of overlap. We want to look at the overall flavor of the situation. So IRS, again, we're going to look at the 20 factors in a second, but the IRS will look at the whole picture. And I think that's appropriate. So they're going to look at the whole picture. They're going to look at control. They're going to also look at whether or not the person can make money or lose money. So for example, just so you know, the Fair Labor Standards Act, the Department of Labor is going to look at similar things. So a lot of times when I just talk to people, and I'll have a drink at the Chamber of Commerce event or something like that, and of course, we'll be engaging in a riveting conversation about independent contractors, because that's kind of my go-to riveting conversation at chamber events. So we're going to look at that. We're going to have this awesome conversation, and so I will say, who is an independent contractor? Now, it's pretty clear if you say, hey, the person that we have come over and work on our copy machines, they're independent contractors. People that we have, so I'm a law firm, right? So we work at a law firm. People that we have, and we don't have anybody that does this, but let's just say we had somebody that, let's just say we had somebody come in and paint the walls. Okay, we're a law firm. We don't do painting of walls as a profession. I maybe somebody around the firm does, but I don't think that's the case. I think for the most part we're practicing law. So bringing painters in, that's not our core business. We bring those painters in, that's pretty clear. Like, they're independent contractors. They could lose, they could mess up, they could have to repaint all the walls. They've got skin in the game here. They potentially could lose, but if they do a bad job, and they might have to come in, because the agreement, of course, is going to say, like, you have to do a good job up to standards and all that, and use this paint, this color cream, And if they don't, if they screw it up and they paint, the walls all purple, and we come in like, purple walls, like that's not our thing, and then they have to come in and they have to repaint it, well, they could potentially lose. Now, if they do a great job and they do it fast and they're really, really good at it, then they could make more money because they spend less time on it. They're paying people less to be here, and we're paying them on a flat rate, right, for the project. That's clearly an independent contractor. If the person I'm having drinks with starts to explain to me that, well, they bring the person in and they get an office and they work on the computer, and yeah, they're doing, we're a law firm, and let's just pretend it's a law firm, and we're a law firm, and they're, they're lawyers and they're working on a computer. Now they're independent contractors because, we just call them independent contractors, but they're doing law and they're talking to clients and they're, writing tips of the week and all that. Well, I'm like, well, that sounds like an employee. That sounds like a lawyer. That sounds like somebody who's no different than a partner or an associate or whatever you want to call your employees at a law firm. And he's like, well, no, we call them, we let them come and go as they want. Like, who cares? That's not the end all be all. That's pretty typical for lawyers to be able to come and go as they want. So the amount of control isn't going to do it. You're going to look at what the business does. What's the overall relationship? Are you treating them like an employee? Is the person able to make or lose money depending on how they do the job? IRS is going to look at this. The Department of Labor is going to look at this too, as well as are the courts, as you'll see from all these. So here are the three general categories. We've got the common law rules. And again, common law has been around for hundreds of years, not necessarily this type of law, but it just kind of comes from, well, anyway, I don't want to get into that. But IRS, so we've got the IRS three basic, we look at financial, behavioral, and the type of the relationship. And again, the financial is going to be, can the person make profit? Can they potentially lose? Is there skin in the game? Is there risk? They're going to look at the risk. Behavioral, we're going to look at control. So there's the control issue, but as you can see, it's just one of three. So what type of control is the business going to have over the person's performance of the duties? What's their reporting going to look like? What are the standards? What are the, what type of expectations are set for this person? And then the type of the relationship. Is there a contract? Hopefully you have, if you don't have a contract with an independent contractor, that's entirely not a good practice. You should have contracts with every independent contractor, setting forth the relationship, making sure that they have work comp, that they have their own insurance, that setting out how you're paying them. There's a whole lot. This is one of the areas, and a lot of areas we don't have to have certain agreements and stuff. This is one you gotta, if you want to call the person an independent contractor, you better have a contract with them, especially if it's going to be an ongoing type of relationship. If I hire somebody to come and do some plumbing on my house, well, there's going to be an agreement. It's pretty obvious that's an independent contractor, right? You're hiring the person, they're going to come over to your house. Say it's a plumber to come over to your business. Well, we're a law firm. We don't do plumbing. So they come over, they fix the plumbing, and then, we sign off on an invoice. The invoice is going to have all this contractual language and everything, and then we're obligated to pay. That's clearly an independent contractor. That smells like an appropriate situation for an independent contractor. It's when you're bringing in people that are doing the type of business that you do, bringing in lawyers, bringing in maybe independent contractor paralegals for long-term stints. It doesn't sound like an employment thing. Those are people that are doing the job, doing the work around here that a law firm typically does, if that's the situation. They're doing the type of work that a law firm does versus a plumber who's coming in to fix the sink or the bathroom or something. Well, we don't fix sinks and bathrooms. So we're looking at the type of the relationship. We're looking at the behavior. I'm certainly not going to tell the plumber what to do. I'm not going to have any control over them. But if it's an attorney or a paralegal or somebody like that that's coming in and doing work for clients, well, yeah, they're going to be monitored. That's control. I'm not telling the plumber what to do. I have an expectation that the plumber does a good job and that they, clean the pipes or fix the sink or whatever. That's the expectation. They're not going to get paid if they don't do it. But if I'm bringing in somebody else who's doing legal type of work, they're going to be overseen. There's going to be a higher degree of control. The plumber who comes in might spend all day on the project. Now, maybe they're billing you by the hour, maybe not. But there is the potential that in a lot of these situations with independent contractors, there is the potential that the plumber could lose some money. Maybe he breaks a tool fixing the sink. So even if he is paid by the hour, maybe he breaks a wrench or breaks his finger. And well, it's not my work comp. So there's some risk there that the person hurts themselves and doesn't hit me on my insurance. There's a chance that they break a wrench, and maybe that wrench is worth more than the overall job. Well, then they lost money on that job. That ended up being a bad financial choice for them, the way it turned out. But there is some risk. Somebody who might be coming in and sitting down and doing legal work, what's their risk? Probably, the risk might be that they could make more doing elsewhere. So there's, just general capitalistic type of risk there. So we could argue that sort of thing. But you can see the two types of relationships, they're going to be different. But this is how they all kind of come together and intersect. And again, the plumber situation, that seems entirely appropriate. Like you wouldn't even second guess that a plumber coming in to fix a sink wouldn't be an independent contractor, because it's just obvious. But you bring in an attorney or somebody like that. Well, that's much less obvious. We have to look at the overall situation and we have to assess it. But it's going to be a much tougher call on that. So behavioral control. The ultimate question here is there a right to direct or control how the person does the work? Am I directing how the plumber does the work? Not really. I don't have any expertise in it. Am I directing how a lawyer comes in if we hire a lawyer as an independent contractor? Well, yeah. We're going to be watching the type of work. There's going to be a higher degree of control. Type of training. Am I going to be giving the plumber some training? Not any training that's going to be worth their while. It's going to be bore them to tears, because the training would be on like legal stuff, versus an attorney who might go to seminars and CLEs and stuff like that. Financial control. Ultimate question whether or not the business has the right to control the economic aspects of the worker's job. And again, you just look at this, you apply it to the plumber versus the attorney, a law firm situation. You could put it in the context of your business, whether your business is sales or hospitality or whatever it is, manufacturing, construction. Put it in that context. And one of the major things is what the person's being brought in to do. Is that part and parcel of what your business is? Or is it just some sort of like help with operations or help to, get the sink working, something tangential to what the business is all about? And the type of relationship. Is there a written contract? There better be. That'll sure help you if there is. Are you giving them benefits? I certainly hope not. I do not recommend paying any sort of benefits. That's treating people like an employee. Reimbursement of costs, not a good idea. Could you negotiate it? Yeah, absolutely. You could negotiate it. But should you be paying for all their costs? Ideally, no. And the reason is because if you're paying for all their costs, like if in the plumber situation, if he breaks his wrench and if he invoices me for it, well, then what risk did he take? He took no risk in coming out and accepting that contract. There was no potential financial loss for him because I just reimbursed him for the wrench that he broke. That's part of the skin in the game. That's part of the risk that independent contractor takes. If you're reimbursing independent contractors for all of their expenses, that's going to weigh against you. That seems like an employee. Laws are in place to reimburse employees for the expenses that they incur on behalf of businesses. Most states have those laws. But with independent contractors, there is no such law. So when you start to reimburse them for all of their expenses, that sure does seem like an employment relationship. permanency or longevity of the relationship. There is no absolute rule that says after they work a year, they need to be an employee. I will just say the longer they work for you, some states might have it. I will say that. Some states might have it for their laws. But as a general rule, the longer they work for you, if it goes beyond 6 months, certainly if it goes beyond a year, that just really, really weighs against you. You're just going to have to explain it to the IRS. And then again, services key, part and parcel of what the business does. So here are the 20 factors, these ubiquitous 20 factors that the IRS is all about, and everybody always kind of knows about them, but then they say, well, but it's all about control, and then you say, no, it's actually not all about control, because you're helping them to understand that they're wrong. And so here's the 20 factors that the IRS, and this all gets to the overall flavor of the relationship, of the situation. So we're going to look at all these 20 factors, and these 20 factors just kind of flesh out the three main categories that we were just talking about: the behavioral, the financial, and the other one that I'm just forgetting off the top of my head. So sorry about that. It's going to come to me at an entirely incorrect time later on today, and I'll be like, oh, yep, it's the third one. Okay, so moving on to the Department of Labor. The Department of Labor has vacillated a little bit in the last few years. Now, there's been a lot of lawsuits outside of the Department of Labor, but under the Fair Labor Standards Act, because people can file lawsuits directly. So a lot of those lawsuits are against Uber and exotic dancers and cheerleaders, so against basketball teams and football teams, and also Lyft drivers and UPS drivers. I think UPS, off the top of my head, it was like well over $100 million that UPS kicked to supposed independent contractors. So the Obama administration, kind of jumping onto this, they issued 2 years ago, because I remember it was about 2 years ago that I did this last webinar on this similar topic. I remember this had just come out. So they issued some guidance. And under the Obama Department of Labor, they said, yeah, we're going to look at the economic realities test. But the thing that they added to the economic realities, and I'll show you the economic realities test in a minute here, is this question at the bottom with this last bullet point. Is the worker economically dependent on the employer or truly in business for him or herself? And so that was the spin that the Obama Department of Labor put onto it. And that question blows a lot of independent contract relationships out of the water. Because it's one thing to talk about control and to say, well, we don't have control. And it's one thing to talk about the nature of the business and how they're not doing the direct work of the business. But then when you start to look into the exact situation to see how dependent the employee is on that relationship, and it's another way of saying, do they smell like an employee or do they smell like an independent contractor? And so the Obama Department of Labor would not really like lawyers working as independent contractors at law firms or paralegals or something like that. If they're lawyers and they're doing it long term and they're there for years and all that sort of thing. But would they? And then if it looked at the plumber situation, they'd be like, oh yeah, okay, well, this plumber, they're just coming in, they're fixing the sink, they'll be there for an hour and then they'll leave and they'll go do a bunch of other things. Versus the employee who just comes into the same office and works there long term, and it's their only job. And it's their only project, their only gig that they have. And it's working for this one company. And so the Obama board looked at it and they're like, hey, in situations where this, quote, independent contractor only works for one company and they're working full time and they're doing it long term, that sure does seem like an employee. Now they're going to look at other factors, but the Obama Department of Labor was pretty skeptical of these long-term independent contractor relationships where the person's really not contracting out and working for other people. They're not going to, they get the plumber situation. The plumber's coming in there, plumber's going to see 6 different businesses in the same day. That's great. And so in a couple of years ago, it just kind of threw a real wrench into the whole system for employers because, wow, suddenly we've got to really worry about these long-term independent contractors who only work for us and don't have any side projects with other companies. Well, that's gone away, and we'll talk about that in a second. But here's what the Obama board looked at. So you know, again, there's going to be some overlap here. And the main reason that I bring up the Obama Department of Labor here is because you know, these federal agencies, I'm not really sure how long they're going to stay in the whole Trump mold. So they've had a switch recently, and we'll see it, but I'm not sure. I wouldn't be surprised if in a few years we kind of switch back to having to examine these independent contractor relationships under the economic dependence test that the Obama Department of Labor put out there. Courts are looking at it quite significantly, and so it just might be the Trump Department of Labor that's the only kind of outlier and just maybe a blip historically. But who knows? We'll see. I still think it's worth mentioning just because it might come back. You never know. So we're going to look at these 6 tests. So we're going to look at, is the work integral part? So that's part of the behavioral part of similar to the IRS test, right? So is the work integral part of the employer's business? So are they a plumber coming into a law firm, or are they a lawyer coming into a law firm to work as an independent contractor? You know, one's clearly integral, one's clearly not. Does the worker's managerial skill affect the worker's opportunity for profit or loss? Could the plumber make or lose money? And that's a big question. The better he does the job, could he make some more money? And if the answer is yes, then that's going to weigh heavily toward it being an independent contractor. Does the worker's relative investment compare to the employer's investment? Who's putting forward the tools? What's the investment there? If I have a lawyer come in and I'm providing them a computer and a desk and a phone and every single thing, and I'm providing their parking for them, and I'm, you know, maybe even giving them a meal stipend or travel stipend or whatever, but I'm taking care of all of their things. Well, they have no investment. They're wearing a suit. There's their investment. They're wearing a suit into work. Versus a plumber who's driving, got a van, you know, plumber van, and it's got a bunch of tools and had to do some training to get up to speed on this. But, you know, the plumber's got some investment. They're driving, they're spending gas, they're doing that. I'm not paying for their parking necessarily. You know, it doesn't have to be 100%. Maybe I do reimburse them for the parking. So, but for the most part, we look at the overall investment. Plumber's got a lot more investment. Does the work performed require special skill or initiative? This one's a little strange, but this one's a little bit more appropriate in a professional context. Is the relationship between the worker and the employee permanent or indefinite? And again, if it's been a long time, it's going to weigh against you. It's going to seem like an employee versus an independent contractor. What's the nature and the degree of the control? So there's the control. You know, what's the employer doing regarding the terms and conditions of their work? How much review, oversight, dictating is going on? You know, the plumber is probably going to show up whenever the plumber wants to show up, and I'm just going to be happy that they show up to fix the sink. Versus the attorney who you expect to come in. You're like, hey, come on in. We're going to pay you for the full day. I want you to be here all day. Show me all the work that you're doing, that sort of thing. There's going to be a lot more control over there. Again, it's not going to be dispositive. It's not going to be the end all, but it is going to be a lot more control. The Department of Labor won't consider, under the Obama Department of Labor anyway, it's not going to consider where the work was performed because the gig economy has kind of killed that. People work from home all the time. They're not going to consider the absence of a formal employment agreement. They're not going to consider whether the independent contractor is licensed by the government, and they're not going to consider the time and the modes of pay, because people are just, paid in various different ways. But these are not going to be factors considered by the Obama Department of Labor. Well, the Obama Department of Labor is no longer the Obama Department of Labor. It's now the Trump Department of Labor. So the Trump Department of Labor came out and said, yeah, that memo from that guidance from 2015, from July of 2015, we're going to do away with that. Now, what they didn't do is really replace it necessarily, but what they did say was, we're going to go back to an economic realities test, which is fair, which is what the courts are doing as well. But the Trump Department of Labor is not going to do any guidance on this. They're just going to do some opinion letters. And fortunately, one just came out a couple days ago. So earlier, yesterday, no, 2 days ago, Tuesday. So one just came out Tuesday. And it was a little off topic, but it had to do with the caregiver industry and the use of doing independent contractor use in the caregiver industry. And so we got a feel for what the Trump Department of Labor, how they're going to look at this. And I will say, again, we talk about the Department of Labor a lot, and it's helpful to look at the Department of Labor. And I think from a risk standpoint, you need to look at what the Department of Labor does. But a lot of the money is coming, just filing directly with the court. So we're going to get to that in a second. But new this week, so the Trump Department of Labor gave us the first insight, and these are the factors that they looked at. And again, you're going to see there's some overlap here. But how is the person paid? Was a payroll service? Is a payroll service? Again, this is in the caregiving industry, so it might not resonate exactly with your industry. Did the independent contractor, did the caregiver need to purchase equipment and supplies? Who was controlling the work? How is it being controlled? How were they being paid? Were they being, did they have hiring or firing authority? Was a background check being conducted on them? Because we typically, conduct background checks on employees. So this is getting into the Department of Labor under the Trump administration. It was getting into the overall feel for the work, and they gave us these factors to look at and consider. Earlier this year, we had a new decision out of California, which jolted the California employers, or should have jolted if you've got employees, or if they were paying attention to those companies out there, that it jolted the way that independent contractors are being looked at in California. And so now California, New Jersey, and Massachusetts, 3 states that had huge Uber settlements and lawsuits, they are now looking at the ABC test. And so that's going to be different than what we see in most states. And it's going to be harder to classify people as independent contractors. So this is a big deal in California, Massachusetts and New Jersey as well. But California is new this year from a court decision. So the company has to prove. And again, the burden's going to be on the company. So, and that's how it is in all courts. It's going to be on the company. So the independent contractor, you have to show that the independent contractor is free from control and direction of the company, right? That's what we expect. We understand that control. And they perform work outside the normal business performed by the company, right? And so that's getting in the nature of the company. We've seen that. And they're engaged in an independently established trade, occupation, or business. That's the one that throws a little bit more of a curveball at us, because an independently established trade, occupation, or business is going to create a lot more criteria for us. So certainly in California, it's always a good idea, but certainly in California, New Jersey, and Massachusetts, that's going to preclude a lot of independent contractor usage in certain industries where it's not, appropriate. But then also, it really behooves you to require that your independent contractor be self-incorporated. So, whether it's an LLC or LLP, whatever it is, but they should have their own independent business that you are then contracting with. And so there's the independent contractor agreement with them. So you definitely want those people in these states, and just generally it's a good rule, to be independently set up. Courts historically, except for in California, Massachusetts, and New Jersey now, courts historically have looked at the economic realities test. And this is the one that's probably the best for you of all of them if you're going to kind of like put one to memory. And again, there's a ton of overlap. So if you're going to put any of them to memory, this is the six-figure one that's very similar to the Trump DOL. And so we're going to look at the extent to which the services are integral, part of the employer's business, right? So we've seen that. That's just like the IRS test as well. The amount of the employee's investment in the facilities and equipment, again, that gets to the risk, and the profit, the relative investment, just like the Obama Department of Labor had talked about. We're going to get into the nature and degree of the control. So there's the control part, right? Again, just one of the 6 factors, not dispositive. And then the employee's opportunity for profit or loss. So we've got that opportunity there. So earlier we talked about the relative investment. Now we're talking about the profit or loss. We've talked about that and what that means. And then the amount of the initiative, skill, judgment, foresight required for the success of the claimed independent and enterprise. And that's just like the Obama Department of Labor, where they look at the skill needed to do the job, and if there's training and that sort of thing, and the more skill that's needed, the more likely it's going to look like an independent contractor. Because, for example, I mean, you've got the plumber. The plumber is going to have the skill. Not just anybody can come in off the street and do the repair the sink. Otherwise, the law firm would find somebody to do it in-house. So that's, the plumber is going to have some specialized skill. And that's going to be, and the specialized skill of specific plumbing is going to weigh more toward being an independent contractor when they've got their own job. And they've probably got their own business too. So that helps out as well. And then the permanency and duration of the relationship. Again, longer term is going to weigh against you as these, concerning these 6 factors. So this is the economic realities test. If you're going to look at any of these and try to kind of commit, look at your overall situation, this is the one that's probably best to look at. And again, this gets applied for the Fair Labor Standards Act for these wage claims that we see all over the country by Uber drivers and Lyft drivers and dancers and cheerleaders and many other people, because it's been a very lucrative way to sue employers. Quickly, the EEOC, this comes up very rarely, but again, like I had mentioned before, the EEOC covers employees. It doesn't cover independent contractors with regard to Title VII and the like. So, and the ADA and ADEA and several other laws. So, who is an employee? And so we're going to look at control. And we're going to look at the overall situation again for the EEOC as well. And this rarely, this is so nuanced when this comes up. But here are the factors that the EEOC looks at. And again, the one that comes up the most with the EEOC is, can the company hire or fire the independent contractor? And that tends to come up with regard to staffing, more of a contingent worker thing. Does the company act like the employer with regard to the staffing agency employee? And that's a big thing that the EEOC looks at, because if they do, then they're kind of part of this joint employer type of thing. But anyway, here are similar factors that the EEOC looks at, and again, very nuanced when this comes up. But these, if it were to come up for you, these are the factors that you're going to want to look at with regard to the overall relationship. Okay, so identifying tips. We're going to, I think, just summing this down, we have the 6 tests under the economic realities test, but overall, those 6 tests are encapsulated within these three IRS tests, right? So, it's the type of relationship. There's the third one there. I knew I was going to come back to it. So the behavioral control, the financial control, the risk, the amount of control that you have over the circumstances and the investment that's going in, and then the type of relationship, how tightly is the person doing business, what's their relative level of investment, can they take a profit or risk on this? Those are the 3 general factors you're going to want to take a look at. And then here's a list of the consequences, just to kind of round out the webinar here. And I do see somebody asked a question, so I'll get to that in a second. It's not insignificant. So with regard to the Fair Labor Standards Act, you could be on the hook for for penalties for failure to pay minimum wage, overtime, as well as liquidated damages penalties, and then attorney's fees as well. But then here's all the stuff under the IRS. If you fail to pay FICA, you're failing to pay taxes on time. These are all the fines that could occur to you. The other thing here is that you have to take a look at your benefits. So you have to take a look at your summary plan descriptions. And if, for example, this came up for Microsoft, 25 years ago, where they had classified all these janitorial staff as independent contractors, and a judge said no, no, no. And so all these janitors then suddenly became retroactively employees, and then as employees under the stock option plan for Microsoft, and that was it's like a lot of money. They suddenly became, like, a lot of them probably became millionaires or close to it, or big deal. They got a lot of money because they suddenly became retroactively employees, and they should have been on the stock option plan. And so then they were able to suddenly, like, get stocks and as employees. And so that was, quite a big deal. So there's a lot. You have to look at benefits as well. But then here are all the penalties and risks that you would owe to the government by misclassifying somebody as an independent contractor when they should have been an employee. Okay, one question, and then we're going to wrap it up. Copy of the presentation that was sent to everybody. So hopefully you have a copy of the presentation. If you don't, please contact us, and I will get it out to you. Thanks for your attention this month. Next month, we will talk about harassment in the context of emojis and a lot of other specifics with regard to harassment and bullying in the workplace. So thanks, and feel free to reach out to me if you have any questions.